And welcome back to For the Record here on the Law and Crime Network. I'm Michael Bryant. We've been talking about self-defense because two huge cases that just wrapped up the end of last week really were self-defense cases. One of those was Sean Foley. So imagine this. You're a 25-year-old kind of lovesick puppy for your girlfriend Miranda. You know that she's been abused by her mom's boyfriend from the age of 12 to 19. She's now 25, an adult, but seems to have a twisted reality on what is okay sexually. And you find that she's in this compromising position with Jimmy Shelton, the ultimate victim in this case, and the guy that abused her for so many years. You're out to protect her. What do you do when you encounter Jimmy Shelton and you perceive an action and movement he makes as some sort of threat? Do you shoot him? Do you hold off? What do you do? In this case, Sean Foley fired 8 times, striking Jimmy Shelton 4 times, ultimately killing him. It was a riveting trial. We heard from the girlfriend. We heard from the defendant himself. Let's talk real quickly before we hear some of that testimony. Andrew Branca, self-defense expert here, is with us. You know, in this case where you have such emotionally charged people, how does that impact the self-defense analysis?
Well, the self-defense claim is always going to be cleanest and most compelling when we're talking about some kind of stranger interaction, meaning there's not arguably some motive other than self-defense for the defensive use of force. The more we have complicated relationships, reasons for animosity, for pre-existing malice, the more it looks like there might be some reason other than actual defense of innocent life for that use of deadly force. And we certainly have a lot of that in this case. Keep in mind, as bad as this person who was killed might be, you're still only allowed to use deadly force against them in defense of innocent life, not for misconduct he might have done prior.
So, Lise, let me ask you. I mean, this was a first-degree murder charge, second-degree murder. The jury found him innocent or not guilty of first-degree and hung. Couldn't figure out the second. I think in part because they liked this guy.
They liked him. But don't forget, I have to take my prosecutor's hat here a little bit and see why they got to that charge. He said, and I'm not going to say the words here on air, but he said to him, you blank with her, you F with her, I'm going to F with you. So that shows the premeditation, because you know premeditation, of course, can be done in seconds. It doesn't have to be hours and days in the planning. So that shows that he was angry. He thought about it. It wasn't just in the moment. It wasn't just self-defense. He was so upset about the molestation that had happened before. He wanted to get back. He wanted to defend his girlfriend's honor, whatever you want to call it. And he said those words to the victim. He thought about it. He loaded that gun and he went after, he went after him.
Yeah, and the prosecution,
That's how the prosecution
would say, of course,
played it.
And the prosecution would say he was just eliminating the competition. Right?
Exactly.
Simple as that. Okay,
Exactly.
Let's listen to Sean Foley on the stand. This guy took the stand in his own defense. Here we go. How could this guy pull a gun and shoot somebody 8 times, hitting them 4 times? I mean, this guy, it looks like he has trouble getting out of bed in the morning. Andrew Branca, expert in self-defense. You just see Sean Foley, the defendant in this case, on the stand. Give me your thoughts from a self-defense perspective.
That is that he does not, in fact, have a very viable claim of self-defense based on his own testimony. It's very emotive. And keep in mind, from the defense perspective, their mission in this trial is to convince at least one juror, and only one juror is all they need, that there's a reasonable doubt that it could have been self-defense. If they can do that, they've stopped the prosecution in its tracks. Now, they don't end up with an acquittal, obviously. They end up with a mistrial, but a mistrial is a lot better, more of a win than a conviction would be for sure. And they managed to accomplish that here. But most of what I'm hearing this defendant testify about is not a basis for self-defense. It's bad things the victim has done previously. He brought a gun with him to a confrontation. He was recording the confrontation. The fact that the other person charged him after he went there with a gun, to my mind, there's an arguable case the other person, as bad as they were, and I'm certainly not trying to defend a bad person, but they have a right to self-defense too. If someone's threatening them with a gun, trying to take that gun away from the person, that's arguably viable self-defense in its own right. Again, as bad as that person is, and as much as they ought to be punished for bad things they've done in their past, self-defense does not allow you to seek out retribution or vengeance.
So in this case, Lise, it seems to me, okay, let's assume that Jimmy Shelton had the right to try to defend himself against a gun. Pretty stupid, though. If you're unarmed, why would you even do that?
Right, and it's as if here the defendant actually escalated this. You know, that's certainly what the prosecution is going to argue, because by tape recording all of this, he escalated whatever was going to happen that night. I mean, we know that there was drinking going on and all that, but he escalated the conversation. The conversation is going on, and by recording it, by doing all of that, by presenting all of that, he escalated the confrontation. There may not have even been a confrontation, because the victim and the girlfriend were having this, clearly this negotiation for sexual favors had been going on, negotiation for sexual favors for a trade for a car or whatever, that had been going on long before the defendant got involved in all of this. And by recording it, by bringing a gun to a knife fight, I mean, all of that, he escalated whatever was going to happen that night.
And so, Andrew, with the self-defense claim, obviously the jury bought it to some degree, because they let him off on the first-degree murder charge, and they couldn't quite figure out the second degree. Do you think that was based on facts or emotion?
Largely emotion. Obviously, this is an emotion-rich case. There's a lot of moving parts here. But keep in mind, we don't know that the jury as an entirety was convinced of this. All it takes for a mistrial is one juror to feel like they still have a reasonable doubt. They could believe it's, say, 80% likely this was not self-defense, but that's not the standard the prosecution has to meet. It has to disprove self-defense beyond a reasonable doubt. If the defense can convince one juror that they still have a biting doubt about the guilt or about the issue of self-defense, that's how you end up with this mistrial. I would expect the prosecution will retry this case. I think they have until September 13th to make that decision, that they'll retry this case, get a different jury, and take another shot at it.
Yeah,
I think that's going to be interesting. Quick to you, Elise, what do you think? Are they going to retry this?
I think so too. The prosecution has enough of a case here because of the comments that were said, you know, the comments that were made to the victim beforehand, that shows premeditation. The taping of the conversation between the victim and the girlfriend, that shows premeditation. The escalation of the gun and all of those things shows that the victim planned this. That shows premeditation. Again, premeditation doesn't have to be planned for a long time. That defies a defense of defending himself. I mean, it just does.
So we'll find out. The jury in this case went for about 12 hours before giving up, for lack of a better description there. So we'll find out if they're going to retry on the second-degree murder charge or not. That's coming up the middle of September. So before we get back to some other goodies, let me thank and excuse Andrew Branca, self-defense expert. I appreciate your insight. This case and the Drake case, both just rife with all kinds of issues, and you are the guy to ask about those things. So thank you for your time today. I appreciate it.
My pleasure, anytime.
Okay, we'll see you next time here on the network. We're going to take a quick break. We'll come back with more. This is the Law and Crime Network.